Hello everyone, Larry Parman here, again broadcasting today from Austria on the Danube River on a Viking cruise. It's been a great trip so far. We were in Regensburg today. Not really enough time. There, it's a great little community. Not so little, 150,000 people or so. But in any event, having a great time. I wanted to go up on the sun deck, but it's closed temporarily because I guess we're going through locks and some of the bridges are so low they have to clear off the top deck of the boat to get through. But anyway, I want to talk to you just a couple minutes today about a question that often comes up. People will say, well, gosh, I have a living trust, revocable living trust, so why do I need, or do I need, a durable power of attorney, a property power of attorney? And the answer is absolutely. So here are a few quick reasons why this step continues to be very important. First of all, using a power of attorney or having a power of attorney gives us the opportunity to catch assets that may not be titled in the name of the trust, that should be in the name of the trust. And if someone's incapacitated or needs help out of the country, whatever the case may be, transferring those assets in, an effective power of attorney will help accomplish that mission. Also, number two would be handling retirement accounts. You may remember that assets, three asset types that are not titled in the name of the trust. First of all, retirement accounts, IRAs, 401ks, life insurance. So particularly on retirement accounts, whether it's, and again, let me make myself clear, those assets are not titled in the name of the trust. Therefore, someone who's holding your power of attorney would be able to help do things, for example, like make decisions on rollovers or required minimum distributions or beneficiary changes. Again, that could be very, very helpful. Number three would be the power to deal with government agencies when addressing issues concerning government benefits, whether it's Social Security, Medicare, even Medicaid, VA, and so forth. Someone holding a power of attorney could act on your behalf because the trustee of your trust technically does not have authority to do that. Another example would be signing tax returns. We'll call that number 4 on the list. If someone's incapacitated, you're filing jointly. Both parties need to sign. The person holding your power of attorney could do that for you. Next would be financial transactions of various kinds, whether it's dealing on someone's behalf when you have a lawsuit, when you have insurance claims, when you have maybe business interests, partnerships, and so forth that are either not in the trust or require some kind of management decision or other requirements that are needed that are not technically trust related. The agent of your power of attorney could be very, very helpful in that regard. And again, non-trust assets, any assets or any liabilities, signing bank renewal notes, for example. That's a renewal note on the liability side of your ledger is not a trust asset. So again, someone who's the agent of your power of attorney could sign a renewal note, an extension, renew a mortgage, refinance a mortgage, etc. And next would be real estate of any kind. So for example, when you own property jointly and you're unable to sign or you're out of pocket or cannot sign, someone holding a power of attorney could execute documents for you. And basically, overall, the last point would be just serving as a backup, someone who has authority to deal with those gap issues, I call these, where technically the trustee is not authorized to act on your behalf. This is why it's critical to complement your revocable living trust with an effective power of attorney. Make one other point. Most practitioners, I'll make 2 points. Most practitioners and institutions believe that if the power is not specifically enumerated in the document, they would not allow you to take that action. That's number one. Number two, we've run into a couple of institutions that stipulate or say that if the power of attorney is more than X number of years old, 5 years old, 2 years old, they will not let someone use the document. So again, key point, important to have a power of attorney even if you have a revocable living trust. That's number one. Number two, we talked about all the reasons where it can help to be a gap measure. And number three, just be alert at what financial institutions may or may not require. It's always good to go to your financial institution, present the power of attorney to them, ask them if they will accept it before you actually walk in and have a requirement, because at that point you do not want to get turned down. Anyway, thanks for listening in. Again, broadcasting from Viking Cruise Ship on the Danube River. Hope you guys are having a great day. Thanks.
If you would like to learn more about creating an estate plan for your family, protecting your assets if you have to go into a nursing home, or transitioning your business, call 405-843-6100 or send an email to info@parmanlaw.com. That's 405-843-6100 and info@parmanlaw.com. Thank you.